Court does call the case of the people versus Shaquille O'Neal Tubbs.
This courtroom session starts with immediate tension, and if you've watched enough criminal proceedings, you already know that when the very first case involves competency evaluations and a defendant refusing to cooperate with counsel, things can spiral fast. Judge Simpson is stepping into a docket loaded with serious decisions, bond fights, probation violations, firearm allegations, and even mental health intervention requests. And here's the thing, the first few minutes of court often tell you everything about the tone of the day. Will this be procedural and routine, or chaotic and unpredictable? Today, it looks like both. Right away, we're dealing with a defendant who refused to even meet his lawyer. That's never a small detail. It raises immediate questions. Does he understand what's happening? Is he intentionally resisting? Or is there something deeper going on mentally? And if competency is in play, the entire prosecution can freeze. That means no trial, no plea, no forward movement. But don't get comfortable, because later today, Judge Simpson will revoke bonds, deny release, and hear one of the cleanest guilty pleas of the day. Question is, who walks out free and who leaves in handcuffs? Stay locked in.
Good morning, Your Honor.
And Assistant Public Defender J. Bellinger on behalf of Mr. Tubbs, Your Honor. My understanding is that, well, I will say, candidly, my client refused to meet with me at the jail when I went to see him on Monday as well. Ms. Noveski has had prior contacts with him. She asked that I submit competency and criminal responsibility as a result of that. So we did do that for the court.
I will, I'm familiar enough with Mr. Tubbs. I feel comfortable signing those requests for evaluation.
Thank you.
Thank you, Your Honor. The people we're going to request to be heard on bond. I'm not sure if the court will hear us with the defendant being absent today. If this can come up.
Is an issue regarding bond?
I wanted to address bond and ask the court to consider denying bond. Count 2 is a robbery. I believe that bond could be properly denied. It's currently set at $1 million. It would ask to consider denying it.
Not without the defendant at least being here and notified that we would be addressing bond, because I'm not sure why he's not coming up. So that you're aware, Mr. Bellinger, so I have 2 cases, but I don't have one set of orders.
Both case numbers should be on.
I see what you did. Okay, hopefully
The CFP has been okay with that in the past.
Have they?
Yes, they have.
Okay, all right. Okay.
In fact, they've told me to do it like that before.
You just follow what they said?
I do.
It's a cooperative game. All right, I'll order forensic evaluations in both of these cases. I'll set a competency hearing date for December 20, what?
23rd.
For Bellinger's birthday. Bellinger's Day.
What's that?
23rd, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the people versus Jeffrey Busencher.
Jacob Gunny for the people, Your Honor.
Assistant Public Defender J. Bellinger on behalf of Mr. Buckinger.
Is it Bucking?
I don't know, Your Honor.
All right.
I'm just covering for Ms. Cannon, so.
All right. What? Never mind.
Yeah.
She just never.
Can you please state your name for the record?
Jeffrey James Buhinger.
Buhner.
Buhinger.
Buhinger.
Like there's no C.
Oh, okay.
Oh,
Sorry about that.
Oh, okay. Thank you. Because we both butchered. All right.
Your Honor, we are just asking to adjourn this matter. My understanding is that Ms. Cannon is seeking discovery.
Oh, okay.
That's correct, Your Honor.
Probable cause conference in this case then will be adjourned. Is this the only thing holding him? Do we know?
I believe so.
Yes.
You do.
Yes, Your Honor.
October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
We'll be in touch with you.
Is there any chance that?
Your Honor, my client is asking to address bond. I'm not familiar with his case. I can just say that obviously this is the only case holding him. He's trying to get his bond reduced, or we would alternatively ask for a PR bond. Are you a member of this community?
Yes, and I just recently had a stroke and I'm having a hard time. That's all.
This is where the defense makes the emotional appeal. Health problems, community ties, personal hardship, these are all classic bond reduction arguments. And the defendant mentioning a stroke? That's strategic. It puts humanity front and center. But Judge Simpson doesn't stay in the emotional lane for long. He pivots straight back to the charges. And those charges? Alleged CSC involving a victim under 13. That changes the gravity immediately. In criminal court, allegations involving children carry enormous weight, especially when it comes to pretrial release decisions. Even if the defendant is presumed innocent, judges are thinking risk, community safety, and victim protection. And look at the judge's wording. He doesn't fully shut it down forever. He says, file it properly. That means if defense wants bond reconsidered, bring evidence, legal arguments, and structure. Not just sympathy. That's a major difference. Question: should serious accusations alone justify keeping someone locked up before trial, or should the burden always stay higher? That's the legal tension here.
Hard time.
Sounds like, Your Honor,
I feel like.
I'm going to say this, given the nature of the charges, CSC charges with an alleged victim under the age of 13,
home confinement?
any request for any change in bond, you'd have to do in writing and
Certainly.
your full motion on it. So at this point, to the extent that that was motion, that I'm going to deny the request. But
I will let Ms. Cannon know.
file that in writing.
Thank you.
Thank you.
We'll get on that, okay?
Court does call the case of the people versus Charles Blakely.
Trevor Maybell for the people, Your Honor.
Your Honor, Stephanie Cannon, on behalf of Mr. Blakely. Mr. Blakely, could you please state your name for the record?
Charles Edward Blake.
And Your Honor, we are going to ask that these matters be set for exam.
Don't have a problem, but you may want to, we're going to have to address his violations.
What about intake?
You have
Oh.
you have to do one. You have to do it at community correction.
Okay.
Mr. Allen.
Your Honor,
Yes.
and to be clear, he can go do the intake. My client is willing to walk over there now and do an intake. He's actually hard of hearing himself, so he has no problem doing this. He doesn't use. Are you gonna test clean for the court?
Yeah.
Yeah, he doesn't do drugs or anything like that. He has no problem doing
He
this.
hasn't reported, he's done nothing.
I was unaware of that aspect of what we're doing here today. My client, he has no problem working with you, the court, or community corrections on this, Your Honor. This is his first and only ever offense. He's not familiar with this process at all. He's willing to go over to community corrections. He'll test clean. He will do the intake. He'll make himself available. He calls me all the time. So this is not him trying to shy away from this court appearance or the process itself, Your Honor.
He needed to go to community corrections.
I understand that, Your Honor.
He hasn't gone over it, hasn't done intake, hasn't done the test, done nothing.
Are you employed? Can you hear the court first of all?
Yeah, I heard he said I did nothing.
Yes, yes.
But I wasn't aware. I have asked about that and I never got a response. So,
Are you working right now?
yes, I am.
Full-time
Yes, I am.
at the Dundee engine plant?
Correct.
Oh, yeah, sorry. Your Honor, my client is a lifelong member of this community. He is fighting these charges, and I do believe hopefully that he will prevail on these charges. He works, he has a wife, he has a household that he takes care of. He is truly, and again, if he's tested, he's going to come back clean. He doesn't use drugs. He's not a drinker, so none of that is going to be a problem in this case.
I don't know that.
I
Because he
understand.
didn't go over.
Your Honor, he can go right now and come back and report it to the court.
He wants to set for exam.
Yes, Your Honor.
Preliminary exam, the discovery is complete. Witnesses have will have their witnesses available on the 7th.
Yes, sir.
People, I meant to say. I'll set preliminary examination October 7, 2025, 9 a.m. As to his bond at this point, his bond is revoked. Maybe you can convince me of something else at some other point, but at this point, defendants remand.
Thank you, Your Honor.
That's one sentence, but it changes everything. Bond revoked means this defendant is no longer walking out. And look at why. Not because of a new charge, not because of violence, but because of non-compliance. This is something many defendants misunderstand. Court conditions aren't optional suggestions. They're active tests of reliability. Miss your intake, skip your test, ignore community corrections, and the court starts asking, why should we trust you later? Defense tried hard here. Job, family, community ties, willingness to cooperate now. But from the judge's perspective, now is too late. The time to comply was before today. This is one of the harsh realities of pretrial release. You can lose your freedom over procedural failure alone. Question: do you think judges should allow one mistake before revoking bond? Or does missing even one major condition prove you can't be trusted? Judge Simpson clearly made his choice, and it was immediate.
Court calls case People versus Procopio Vitale.
People, Your Honor.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Vitale, who's making his way to the podium, Judge.
Go ahead.
Your Honor, there's a,
For an adjournment.
oh, state your name, Mr. Vitale.
Procopio Vitale. Thank you.
Your Honor, there's a violation of probation in circuit court. I'm asking the court for a brief adjournment so I can see what's happening there. Also,
Is it set for a hearing?
it's set for October 2nd, Judge, with Judge Slay.
All right.
And we're also trying to explore a
Options.
recovery court.
Okay. So I'll adjourn this to October 9th, 2025, 9.
All right, and
Bond will continue.
thank you, Your Honor.
Court calls case People versus Tanya Zecki. I probably messed that all up big time.
Before we burn yours, hope you're on behalf of the people, Your Honor.
And Assistant Public Defendant Nicholas Bukovitz on behalf of Tanya Zarnicki.
Ma'am, can you unmute?
Tanya Lynn Zarnicki.
Okay. And I apologize about butchering your name. I have a nollie process where the people are dismissing.
No objection from the defense, Your Honor.
Case is dismissed
Thank you.
on nollie pros. Thank you.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
That's for people.
David I. Goldstein, appearing on behalf of the defendant. May we approach briefly, Your Honor?
Yes.
Your Honor, briefly, we're asking for an adjournment till the 16th of October to have a we're working on a global resolution for all of his cases.
All right.
And
Go ahead. Record should reflect there's been a brief bench conference. I will adjourn the probable cause conference October 16th, 2025, 9 a.m.
Your Honor, the only thing that's holding him at the present time, he has 2 other cases pending, but he's on a personal bond on both of those cases. One is a Washtenaw County felony, one is a federal felony. None of his charges involve any allegations of violence. They all involve possession of weapons, but there's never been an indication that he has ever used these weapons. He has he's a lifelong resident of this county. He has no other ties to any other community. He does not have a violent history. And therefore, we think $150,000 bond in this case is excessive. I know I made the same argument last week, but I'm making it again because we are working toward a resolution. I indicated something at the bench that I think the court would consider.
All right.
And I do think the court heard this argument last week and recalls the concerns that people expressed specifically related to text messages that the defendant was exchanging related to the sale of firearms.
Yes.
And the concerns that have surrounding that. I don't have any indication that I'm aware of that has engaged in violence in the past, but I have concerns about firearms. They were being possessed and potentially sold. I would ask the court continue the bond as currently set.
All right.
I do understand that the 16th date was the date that Mr. Goldstein discussed with Mr. Panatra from my office, so that is a good date.
All right. So October 16th, 2025, 9 a.m. I considered this issue before. I'm giving you the same ruling. I don't see that anything's changed. It certainly has not in this court's mind. Motion for bond reduction is denied.
This ruling tells you exactly how bond reconsiderations work. Defense brought the same arguments as before: nonviolent history, community ties, and no proven use of weapons. But the prosecution brought the heavier concern: text messages. That's the difference maker. Because when firearms are allegedly being sold or moved around, courts start thinking beyond possession. They start thinking distribution, access, and future risk. And Judge Simpson makes it clear: nothing has changed. That phrase matters. A bond motion isn't a second chance to repeat the same pitch. It requires changed circumstances. New evidence, new facts, new conditions. Without that, the judge has no reason to reverse himself. This is one of the toughest balancing acts in criminal law. No violence yet, but possible danger ahead. Should courts base decisions on proven harm or credible future risk? That's the core issue. And today, the risk argument won.
Fine. Court does call the case of the people versus Dominic Brewer.
Trevor may vote for the people, Your Honor.
So finally, she's decided to do something today.
Good morning, Your Honor.
Yeah, she's just running around, getting in everybody's way, but it wasn't anything. Go ahead, I'm sorry.
Good morning, Your Honor. Ken Dadish on behalf of Mr. Brewer. Brewer, can you please state your name for the record?
Dominic Brewer. Thank you. Welcome back.
Thank you. You guys miss me?
You know, don't go too far. I just said welcome back.
All right.
Alan missed you. I did.
Yeah,
I didn't even know you were gone. Go ahead.
you noticed though.
All right.
What's the notice? Thank you.
All right, what are we doing?
We're here for plea, Your Honor.
Oh, there is a plea form. All right. The plea form indicates that the defendant is going to be pleading guilty to the charge of operating while intoxicated, second offense, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's accurate, Your Honor.
Yes, Your Honor.
All right, very good. May I have him sworn?
Right hand, do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
State your name.
Dominic Brewer. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order any rehabilitative services the court deems necessary, as well as community service. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir. Tether now.
Okay.
Well,
It's not probation or. You're under the jurisdiction of any other court?
no.
Have you ever been to prison?
No, sir.
And you're not on probation or parole. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
February 1st, 2025, at the location of Prospect Road near Cherry Hill Road in Superior Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
All right. Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What did you have and how much?
I had couple shots of Bacardi, and I had just opened a Bud Light.
This is textbook plea procedure. Notice how methodical Judge Simpson becomes. Every right explained, every consequence outlined, every waiver confirmed. That's not just formal, it's protection. If Brewer ever tries to challenge this plea later, this record matters. And Brewer is unusually direct. He admits drinking. He admits driving. He admits prior convictions. That creates a clean factual basis for the plea. And that's crucial. No ambiguity, no confusion, just accountability. But there's something chilling underneath the casual tone. Bardi and Bud Light. Sounds light. Sounds almost funny. But this is a second offense. That means the system sees a pattern. And patterns scare judges more than isolated mistakes. Because repeated drunk driving means repeated public danger. This case now shifts to sentencing. And sentencing is where everything changes. Question: should second-time drunk driving offenders get rehabilitation first or jail first? Because courts across America still wrestle with that.
Bacardi and Bud Light?
Yes, sir.
Oh, what a combination. All right. Were you stopped by the police?
Yes, sir.
Why'd they stop you?
They say I went over the middle
Line.
The
They,
middle line.
some erratic driving?
Left to the middle of the lane.
Okay. And you're not disputing the right of the police to stop you in this case, are you?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital
Yes,
or
sir.
to the police station?
Uh,
Well, or both.
both.
Did you go to the hospital?
Yes, sir.
Was there a blood draw?
Yes, sir.
And what were the results of that blood draw?
0.11.
There should be another number, but 0.110.
Oh, yeah.
1110, you're correct.
All right. You have any reason to dispute those test results?
No, sir.
All right. Had you previously been convicted on or about February 13, 2024 in the 14A2 District Court of operating while impaired and or operating while intoxicated on or about October 21st, 2024 in the 53rd District Court in Livingston County?
Yes, sir.
All right. Sir, I have to advise you that if I accept your plea and if between the time of plea and the time of your sentence, in this case, you commit misconduct as defined under the Michigan court rules, any sentence evaluation or any recommendation, the court would no longer be bound by. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, sir.
No, Your Honor.
All right. And I'd also advise you, sir, that you could not withdraw your plea if you did that. You understand that?
Yes, sir.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is so satisfied. Thank you, Your
All
Honor.
right. Court will accept the defendant's plea to count two, guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
October 14th at 10 a.m.
October 14th, 2025, 10 a.m. before Judge Barr. Bond with its conditions will continue. Right?
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Mia Caruso.
Andrew Banas for the people.
Oh, she's got another one.
Kevin Daddish on behalf of Ms. Caruso, who's appearing to my right. Can you please state your name for the record? Mia Caruso.
Thank you.
Honor, we're just going to be asking for a brief adjournment to start plea negotiations with prosecution.
That objection, probable cause conference, October 16th, 2025. 9 a.m. bond continue. Thank you, ma'am. Court does call the case of the People versus Ishmael Davis.
This is Lieutenant Deputy Leba for Mr. Davis.
Your name, sir?
Ishmael Alexander Davis.
Thank you.
And Your Honor, we are waiving preliminary exam.
Is that correct, sir? You're waiving your right to have a preliminary exam?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thank you, Your Honor. And Mr. Davis has also asked me if we considered revising his bond to a personal bond in this matter.
Are you going to do the circuit court arraignment?
Yes, Your Honor, we will acknowledge receipt of the information, waive formal reading, and stand mute.
Defendant never waive for reading. Court will enter not guilty plea. Retrial in this matter will be set for
October 7th at 1:30 with Judge Cunney.
October 7th, 2025, 1:30 before Judge Conkey. Esteban.
He's hoping to get into treatment once he's released. He doesn't release to treatment at this time, but he believes that he'll be able to get into treatment a little bit faster if he's given a PR.
This is one of the most common defense strategies in modern criminal court, linking release to rehabilitation. And honestly, it can be persuasive. The argument here is simple. Let him out, let him get treatment, let him stabilize. That sounds reasonable, but there's a problem. He's already got another pending case. That changes the judge's risk assessment immediately. Because from the bench, treatment sounds great, but accountability comes first. And Judge Simpson makes a subtle move here. He doesn't outright reject the idea of treatment. He rejects making the bond change himself. That's important. He's basically saying, let the next judge, the one taking over long-term, decide if release fits the bigger picture. Smart judicial restraint, because bond isn't just about helping someone, it's about public safety and court compliance. Question for you. Would you release someone early if it meant faster treatment? Or would you keep them locked up until the system catches up? That's the dilemma.
Really?
Yeah, and they also, Judge Washington ordered a tether to be placed on me in 24 hours after getting off.
So he has another matter pending?
Yes, Your Honor, but that would be a misdemeanor.
What?
Yes, Your Honor, a misdemeanor in 14B.
But enough of a misdemeanor to have a tether.
Yes.
And he needs treatment.
Yes.
All right, well, then he's going before Judge Kunke on this matter, and I think if she deems that appropriate, then that's fine. But at this point, I'm going to deny any request for a change in bond. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus John Cassidy.
Assistant Public Defender, Chinaki Kayak and Ruli, Your Honor, on behalf of Mr. John Cassidy, who is a person. Mr. Cassidy, could you state your name for the record, please?
John Cassidy.
Your Honor, this is going to be a waiver. Mr. Cassidy has been accepted into the treatment court, the circuit court treatment court.
All right. Thank you. All right, sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information. I just.
You lost there for a minute or what?
I have a mint in my mouth and I took a.
What?
And it just
What?
broke into
Oh,
pieces.
no, we'll wait. Fine.
Sorry.
Jeez, I can really.
We acknowledge receipt of the information. Stand mute, asking the court to enter and not be a guilty plea on his
Defendant
behalf.
having waived for a reading, standing mute, court will enter not guilty plea. Pretrial will be set for
November 19th at 1:30.
November 19, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you, sir.
Thank you. Bond will continue. Good luck to you, sir.
Thank you.
Court does call the case of the people versus Nathaniel Lucas.
And on behalf of the people. Assistant Public Defender Hannah Apple, on behalf of Mr. Lucas. Mr. Lucas, will you state your name for the record?
Nathaniel Reed Allen Lucas.
Thank you.
Yes, you may.
Your Honor, we are asking for an adjournment of the probable cause conference. We are missing video discovery as well as the complaining witness released medical documents from the University of Michigan to the police, and we have not received those medical documents.
This may sound boring on the surface, but this is massive. Missing discovery can completely reshape a case. Video evidence, medical documents, that's often the backbone of prosecution. Without it, defense counsel is fighting blind, and that's dangerous. Because imagine being forced to make decisions, waive hearings, discuss pleas, challenge facts, without seeing the evidence that supports the allegations. That's not justice, that's guesswork. Judge Simpson immediately recognizes the issue. And notice, no pushback, no pressure, just adjournment. That's because discovery disputes can become appellate nightmares if mishandled. If the prosecution has evidence and hasn't produced it, that can affect fairness, strategy, and even constitutional rights. And sometimes, hidden in delayed discovery, there's a surprise. A weak injury report, a missing witness statement, a video that tells a different story. Question: should prosecutors face penalties when key evidence isn't ready on time? Because delays like this can change lives.
Okay.
Discovery.
And that's going to take a minute probably to get the medical through.
The way that the report read made it seem like the officers had them, but they weren't attached to the report, so I'm not certain.
And not for retirement, we don't have them to follow, so I don't see if they have them or she just signed the release.
Yeah, I think something, even if they get them, there's something that may need to be done in addition, but all right. Probable cause conference, October 16th, 2025, 9 a.m. Hopefully we can get that all done then by then. Okay.
Thank you.
Thank you. Court calls case people versus Antonio Cornelius.
Glenn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cornelius, who appears by Zoom.
How long have you been over there?
What's that?
How long have you been over there?
I'm omnipresent, you know, I've been here all this time.
I'm omnipresent. Okay. We gotta talk about this hat. Anyway. Sir, can you please state your name?
Antonio Cornelius.
Thank you.
Your Honor, today's the date and time set for the probable cause conference. We are efforting to get Mr. Cornelius into the Kalamazoo mental health program. There's a packet we have to put together. We're working with the prosecutor's office. We're last in touch with Ms. Feltis, but I guess maybe Ms. Douglas will take that over. Who has this case now? Okay, yes. Ms. Feltis will probably continue.
What'd you say?
Ms. Feltis will probably continue to help us get the packet together. Right?
Why, Miss Douglas doesn't like you and she won't help you?
I guess that.
Okay, all right.
Too many hats, too many hats. It's Cornelius. So we're trying to get the packet together to make sure he gets into the Kalamazoo mental health program.
Sounds like.
How much time do you need?
I think maybe 3 weeks. We have to send him the packet. He has to be evaluated. I don't know what their schedule is like.
Well, he's out, so why don't I do this? I'll adjourn it out to October 23rd. Let that process happen, 2025, 9 a.m.
This is one of the more important cases today, even if it doesn't look dramatic. Why? Because this is where the court shifts from punishment to intervention. Cornelius may be entering a mental health program, and that can radically change the outcome of a criminal case. Programs like this aren't soft options. They're structured, strict, monitored, and often harder than people realize. The goal isn't just avoiding jail, it's reducing repeat offenses by treating the root problem. That's huge. Judge Simpson keeps bond in place and gives time for evaluation. That tells you something. He sees potential here, potential for treatment, potential for stability, potential for a different ending. And honestly, these are often the cases where the system works best. Not because someone wins, but because maybe they stop coming back. Question: should mental illness change how we punish crime, or should the law stay the same no matter what caused the behavior? That's one of justice's hardest questions.
Bond will continue.
Thank you.
Thank you. Court calls the case People versus Christopher Minor.
Trevor Mayville for the people here.
And with that, on behalf of Mr. Minor, who is appearing to my right. Minor, can you please state your name for the record?
Christopher Minor.
Your Honor, we are going to be asking for an adjournment. I believe there is a pending case, so we'd like to wait for that for a potential global resolution.
All right, when is that case out?
Your Honor, I know that the defendant has a pending probation violation.
Oh, okay,
in the court.
but we don't know when. All right. I'll adjourn this out then. And that's the only, so that and this is holding him.
Okay, I mean, that's holding him in any case, but I thought that there was another case that hasn't been authorized yet that we're waiting on. I may have misunderstood APA level.
October 16, 2025, 9 a.m.
Okay.
Give you a chance to
Thank you.
Bond continued. Court does call the case People versus Maurice Anthony. This is been a second release case. You can do this, Ballinger. Just come up to the podium and just put your name on it. I'll deal with it.
Okay.
Okay.
Assistant Public Defender Jay Ballinger.
This individual is rented out to another county, so he's someplace else.
Certainly. We would just ask for an adjournment for purposes of the writ then.
Oh, see, he followed right into that. Probable cause conference will be adjourned to October 16, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
For what it's worth, I have enough trouble keeping a track of my own cases.
I know, but I thought you could do this one without, and you did it flawlessly.
Thank you. We try.
Court calls the case People versus Megan Moses.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Moses, who is now approaching.
Your name?
Megan Moses.
All right. What are we doing?
At this time, Your Honor, we're waiving the preliminary exam. I do have a completed waiver here.
All right. Is that correct, ma'am?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it? Yes? You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
I understand.
All right, people also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Yes, we are now as the receipt of the information. We'll be standing mute as to charges and asking the court into a not guilty plea.
Defendant name and waive formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for October 8th, 2025, before Judge Conlon. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Al Nielsen or Osorio Martinez.
And on behalf of the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Osorio Martinez, who is now approaching.
Your name, sir?
Eddie Nelson Osorio Martinez, sir.
All right.
At this time, Your Honor, we'll be setting this matter for preliminary examination. To my understanding, all discovery is complete.
People have their witnesses available on the 7th.
What is it? Just to get that.
Preliminary examination, October 7th, 2025, 9 a.m. before Judge Freshour. Bond continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Thomas Robinson.
Trevor Mabel for the people, Your Honor.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Robson, who's now approaching.
Your name, sir?
Thomas Robson.
Thank you. What are we doing?
At this time, Your Honor, my client would like to set this matter for preliminary exam. To my knowledge, all discovery appears to be complete.
People have their witnesses available the 7th.
Yes, sir.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. before Judge Perry. Bond will continue. Thank you. Court does call the case of the people versus Derek Stewart. Evan?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stewart, who's approaching now. Mr. Stewart, will you state your name for the record?
Mr. Derek Stewart.
Thank you.
Your Honor, my information is that we are still awaiting placement at the forensic center for him to be restored to competency.
And here we hit one of the slowest moving parts of criminal law, competency restoration. This defendant has already been ruled incompetent. That's huge. It means legally, he cannot assist in his own defense. No plea, no trial, no sentencing. Everything stops, and that's constitutional. The system cannot move forward if the defendant doesn't understand what's happening. But here's the problem. Forensic centers are backed up, sometimes for months, sometimes longer. That creates a painful limbo. Victims wait, families wait, the defendant waits, and the court waits. Judge Simpson pushes the review date forward just to keep the case alive. That's practical, because if nobody tracks it, these cases can disappear into delay. But here's the hard question. How long should the state be allowed to hold someone waiting for competency restoration? That's not just legal, that's ethical. And courts across the country are struggling with that exact problem.
The report I had was dated March of 2025, I think it was.
Right.
He was out of custody at that time. He was brought back in on a bond violation, but we're still waiting that information. I contacted the forensic center yesterday to see if I could get an update. I have not received a response yet.
Okay. Because we're on a competency review, basically.
Yes.
Yes.
He was found incompetent but restorable.
Let's put this out to October 30th. If we figure out something before then certainly I can move that date around. Let's put it there so we don't lose track. October 30th, 2025, 9 a.m. Bond continue.
And that closes out another packed day in Judge Simpson's courtroom. What did we see? Competency battles, bond denials, bond revocations, plea deals, mental health intervention, discovery fights, and case after case showing how much criminal court depends on procedure. That's the biggest lesson today. Procedure controls everything. Ignore conditions, bond gone. Need treatment, court may pause. Missing evidence, case gets delayed. Found incompetent, everything stops. Judge Simpson stayed consistent throughout. Firm, procedural, and direct. He didn't overreact, he didn't underreact. He followed the legal framework. And that's what separates strong judges from unpredictable ones. Some defendants today bought themselves time, some lost freedom, and some moved one step closer to final judgment. But every ruling carried consequences far beyond the courtroom. Now I want to hear from you. Which ruling today do you think Judge Simpson got right, and which one would you have handled differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.